In our introduction, my Lord, we say that the state has led further evidence of Sergeant Mabasa, whom it had recalled to give further evidence on the additional photos of Mr. Mngube, who is accused number 3 in this court, and the additional photographs are marked Exhibit S in brackets D. And Exhibit SD depicts Mr. Mngube's appearance with a gold tooth on the left quadrant of his upper jaw. Through the legal representative of Mr. Mngube, Advocate Mnisi, they've disputed that at any relevant time, inclusive of the 26th of October 2014, Mr. Mngube had a golden tooth or a gold insertion on his upper jaw, the left quadrant. Now, before cross-examining Sergeant Mabasa on the additional photographs, Mr. Mngube has made an application that he be subjected to undergo an examination by a dentist or a forensic orthodontist in private practice and also employed at the district surgeon in order to rebut the allegation that he had a golden tooth. Now, the matter was adjourned in order for Mr. Mngube to bring that substantive application, which was done this morning. Now, as to the law, my Lord, the government has understood the court's question on Friday and also the objection by my learned colleague, Advocate Sibanda. I'll put the same in 2 categories, my Lord. The government has understood it from the court was that, is that procedure allowed for the applicant when he's supposed to cross-examine a witness, then ask for time to be given to him to allow him to consult a specialist, dentist, orthodontist, in order to rebut the state's case rather than the accused proceed with his cross-examination and place his version to the witness, then perhaps later, either in allowed by the court in evidence in chief or in the defense case, then ventilate that defense with the report by the orthodontist. That's how I understood the court's question, and then subject to correction, my Lord. And Advocate Sibanda then reiterated the same point to say that procedure to stand down and allow Mr. Mngube to be afforded an opportunity is not the right procedure. He should proceed to cross-examine Sergeant Mabasa, then in the defense case, then he can raise whatever rebuttal evidence that he wishes to. Now, my Lord, with the law that I've managed to find, and one authority that I found from this division, but albeit in Johannesburg, there is some authority to say sometimes procedures must yield, but I'll address that towards the end of my submissions. Now, at 2.4, as to the law, my Lord, that is applicable, Advocate Mnisi has to length covered the Constitution, its application in matters of this nature. And I'm not going, my Lord, for brevity's sake and time's sake, to regurgitate the issues, my Lord, except and suffice to state that, my Lord, the Constitution guarantees the right to a fair trial, which includes the right to adduce and present a defense. And in criminal proceedings, the right to a fair trial, including the right to adduce and to challenge evidence, is explicitly stated in Section 35 in brackets 3 in brackets I of the Constitution. And this right, my Lord, we submit, it includes the right to cross-examine witnesses and to present one's own case. Now, the other piece of law that I found, my Lord, which may have application in this particular application is Section 37 in brackets 3 in brackets A of the Criminal Procedure Act of 1977, which states as follows, and I quote, Any court before which criminal proceedings are pending may, and subsection A says, in any case in which a police official is not empowered under subsection 1 to take fingerprints, palm prints, or footprints, or to take steps in order to ascertain whether the body of any person has a mark, characteristic, a distinguishing feature, or shows any condition or appearance. Order that prints be taken of any accused at such proceedings, or that steps, including the taking of a blood sample, be taken which such court may deem necessary in order to ascertain whether the body of any accused at such proceedings had any mark, characteristic, a distinguishing feature, or shows any condition or an appearance. My Lord, just to elucidate on this point, I'll submit that a gold tooth or a gold insertion falls within the square of this subsection 3A, which relates to a condition or an appearance or a distinguishing feature, because that's the feature by which some of the witnesses in the house said they identified one of the intruders with. So this section, my Lord, I'll submit that it finds applicability in that the court may itself, mere motu, or by application by any of the parties, invoke this section to have an accused person appearing before criminal proceedings in front of it to order that an accused person be taken for a medical, dental examination, my Lord. Now, the question to be determined, I've already alluded thereto, my Lord, at the beginning of my submissions, whether or not this procedure finds favor in the law or in practice. And I say, my Lord, that this court is empowered to take steps in order to determine whether the body of Mr. Mngube had any mark, characteristic, or distinguishing feature, or showed any condition or appearance. In other words, whether Mr. Mngube should be taken for a dental examination to determine whether or not, at the time of the incident or at any time thereafter, or as alleged by the state, had a golden tooth. And the authority that I found for that submission, my Lord, is S versus Maphumulo, 1996-2, South African Criminal Reports 84, in brackets N, where the court said regarding the taking of fingerprints from the accused, and the court stated that, and I quote, "From a mere reading of section 37(1), 37 in brackets 1 in brackets A, in its context with particularity to section 37(1), it appears a court will be empowered only to authorize the steps which the application was brought to achieve where the police official in question does not have the authority or power under section 37(1). Indeed, the prima facie meaning appears to be correct," and close quotes. And this view was further endorsed in the case of Nkosi versus Balo nominee officie and Anere, 1994, 3 SA 148T. Now, these are the submissions that we make, my Lord. We submit that Mr. Mngube, indeed, under the Constitution, does have a right to independent medical examination and examination by the district surgeon to determine the issue that he had a distinguishing feature or a particular appearance, to wit, a golden tooth, in order to ventilate his defense, my Lord. We submit that the aim of recalling Sergeant Mabasa was to introduce photographs depicting accused number 3 with a gold insertion, And we've already stated that some of the witnesses in the house, they've also said one of the intruders had these particular features. Then it is with that in mind, my Lord, that Mr. Mnube makes this application for his examination to rebut the allegations against him. We also submit, my Lord, further that the evidence is relevant and germane to the issue before the court, which pertains to the identification of the two perpetrators, one of them allegedly bearing a golden tooth in one of his jawlines. And then we submit, my Lord, that in determining whether or not evidence is essential to the just decision before the court must consider the value of the evidence, its reliability, whether it could be created to meet the problem facing the accused. We submit that will not be the case, my Lord. The submission is that Mr. Mapisa will be examined by the district surgeon who will provide their report. The report will arrive at the doors of the court via the registrar, and thereafter it will be availed to Mr. Mnube via his lawyer. So there's no issue that Mr. Mnube can go and temper or modify that report, my Lord. And we are not even sure whether that report will support the state's aversion that he had a golden tooth, or it will rebut the state's aversion to that extent, my Lord. Now, my Lord, we say in reply to the state's concern that this evidence is out of sequence, and indeed is going to be so if it is allowed, my Lord. We submit that there are time-honored procedures regarding how evidence is brought to court for the speedy and efficient decisions on trial matters, so that can take place, my Lord. We know the time-honored procedures of evidence in chief, cross-examination, and re-examination. But we submit, my Lord, and this is the authority that I found to that extent, that there are certain exigencies where procedure must yield to the interest of justice and in arriving at the just decision of a matter. And this authority, my Lord, it's the matter of, and I'll avail a copy to the court now, it's a matter of S versus Kreitcher and others, where in this matter, my Lord, I'll go through the facts briefly so that context can be placed. In this matter, my Lord, accused number, it was during a trial within a trial. And then accused number 2 had testified.
Yes, I know that case.
You know that case, my Lord?
Yeah, my brother.
Lamont. Yes. So, my Lord, let me then go, because the court knows the case too.
Yeah, but you can read it for.
Yes. But I was just summing up the facts for the people that do not know the facts. Okay, my Lord. Then accused number 2, having testified, cross-examined, re-examined, he then saw one of the police officers during the proceedings to whom he was previously presented to make a statement, and he says, this particular officer, I refused to make a statement to him, and he left me alone. But this, subsequent to that, I was pressurized by this set of police officers, and having been unable to withstand the pressures of assault, I then made a confession. Now I want to be called, me as accused number 2, out of sequence, because I've already testified, to testify on this officer because I see him here in court and I don't know his name. The Honorable Justice Lamont then went on to deal with what we've dealt with previously regarding these applications, that is section 186, 167, 166, and then ordered that indeed that exigency required that the accused be recalled as a witness in his case, because he has already testified, But importantly, it touches on whether or not procedures are strict, whether we should always stick to cross-examination, evidence in chief, cross-re-exam. Then he went on to state, my Lord, the following. Firstly, that there was no prejudice to the state because the only prejudice that will be there, it will be the fact that evidence is led out of sequence. Nothing more, nothing less, my Lord. And then the court went on to say further at paragraph 20 of it's page 3566. The court says, and I quote, "It seems to me that the only prejudice which there can be to the state is that the order which is customarily followed in the production of evidence is not followed. There is a time-honored procedure in the way evidence is presented to a court to ensure good, orderly delivery of facts and information to the court, so as to enable expeditious decisions of trials to take place." That is at 3567. And then further, my Lord, at 3568, the court went on to say at paragraph 20 as well, at line 20, I'm sorry, "The issue before me is whether or not an accused can, out of sequence, tender himself as a witness and apply to the court to be recalled. It does not matter how it was brought to the court's attention that the evidence is necessary. Hence, an accused can make an application. As to the witness himself, is that the evidence is given before a court in an orderly fashion, and generally speaking, there should be no deviation to the rules. However, occasions arise when new evidence becomes available, which is relevant and which should be let, my Lord." So, in answer to the concern by the state, my Lord, sometimes where the exigencies arise, procedure yields to the normal way we do things, my Lord. So, my Lord, I'll submit that the applications will succeed on those results. As the court proceeds.